The drama that unfolded at the late Ken Okoth's funeral service yesterday, when it was made public that the late Member of Parliament may have had a child with Nairobi County nominated Member of County Assembly, I should say, Anna Thumbi, has provoked a big debate about children born out of wedlock. In many cases, the rights of such children go unrecognized. So what legal options do these children have, especially when it comes to division of assets? NTV's Charity Munge has been finding out.
It's a familiar scenario. A prominent person dies and children previously unknown to the man's family emerge, saying he was our daddy too. Confusion and legal battles ensue as courts are forced to intervene to rule over the rights of the children, seeking to be included in the division of the assets of the deceased. The issue is now a hot topic of discussion. It turns out the law already anticipates these issues and provides solutions, as lawyer Peter Munge explains.
Whether it's a child born by a single lady not married, whether it's a child born in a proper union where there's a married man and a woman properly married under the Constitution, under what is required in law, or is a child who is adopted, or a child in a foster home. The Constitution does not separate. It says every child has a right. That if a child is born by Mr. Kamau as a father, that child has a right to that name. It doesn't say that there must have been a marriage between the mother and the father.
Legislator Millie Odhiambo now seeks to present a bill before Parliament that would ultimately force men to declare their children. But there is a hurdle.
And what she needs to ask herself, does she see herself going through that bill, even the first reading, right? Or even through the committee stage when it's a house where majority are men. And probably, I say probably, some are victims.
When the family dispute the case of the late Kibra MP Ken Okoth reached the courts, his burial was temporarily halted. Lawyer Munge says this was unnecessary as more options could have been explored before the orders were issued.
You can get a sample from a sibling or a close relative to the deceased person and confirm whether indeed that child is for the deceased person. If there is a will and the will has admitted or acknowledged that child, why would you stop that at a funeral?
The law also provides for the division of the assets left behind by the deceased. It caters for all his children, his widow and other dependents. All this not in the spirit of equity, but rather that of fairness.
The principle that they take into account is that all persons are equal before the law. And what the court consider is, what are the assets, right? Number two, how many are you, right? Then you go from there. Number three, is there a widow? And did she contribute, right, to any of acquisitions of these assets? Or is there asset which is a matrimonial asset?
Peter Munge, however, advocates for the ideal situation whereby a man prepares a will to take care of all his loved ones in the event of his death.
And one thing I keep telling men is that when you are gone and you're up yonder, and we have a will, and we are reading your will and says, these are the children of Mr. XYZ, and you see, we give the names of those we know, people know, and those others. What would the people do? Hawatakuchapa.
And so it seems amicably resolving such family conflicts may be the best option, especially during a time when emotions arrive. Charity Mwangi, NTV.